Welcome to the Ask the Expert Show.
Happy Thursday to everyone, and I'm Rhonda Hines. And tonight we have an exciting show for you. Tonight we are joined by our estate planning expert. He's an attorney in that field, Paul Labiner. And Paul is going to talk to us tonight about the Secure Act. But Paul, I have to ask you, are you enjoying the fact that we're getting longer days now?
I am enjoying the fact.
I am too. I'm looking forward to be able to go home after work and actually go biking still, right?
Yeah,
and go to the beach.
And the weather is warming up a little bit.
Yeah, it is. It's feeling good. I can't believe that we've already kind of blown through winter and now we're hitting those summer months, which means we're going to be doing 90-degree weather again.
It's on its way.
Yeah, it came quickly. Well, tonight I want to ask you, we talked a little bit on the last show about the Secure Act, and people called in and had some questions about, kind of explain more about it. Why don't you again define what the Secure Act is and how that impacts people?
Sure, I'd be glad to. And it's a pleasure to be here this evening with you, Rhonda.
Yeah, thank you.
And the Secure Act is probably one of the most important pieces of legislation that has come about in the retirement planning arena and the tax planning arena probably in decades.
Wow.
Okay.
To say decades, it's pretty powerful.
Oh, no, it is. It's a very powerful piece of legislation. And many people clearly do not understand the implications of what this new legislation involves. Everybody thinks of it as maybe an opportunity to save taxes. This is nothing more than a tax act. Okay, and
did you say a tax act?
Yes, a tax act, because there are serious tax implications as it relates to this new Secure Act that many people are not aware of.
Yeah.
And let me tell you a little bit about the act, what some of the implications are, tell you what, some of a brief overview of what it does.
Yeah.
Because it is pretty impactful in terms of the changes that have been made.
Sounds pretty heavy.
It is pretty heavy. And there's some positives to it. And let me tell you some of those positives.
Okay.
Typically, the minimum required distributions as it relates to retirement assets, an IRA or a pension plan, a 401k, is that you can defer that money until age 70 and a half. Okay? You can begin to start taking minimum required distributions without an additional tax penalty at 59 and a half. But if you want to defer that money and have that money grow on a tax-deferred basis and have the ability of that money growing free from creditors, you can defer that prior to the new tax act to 70 and a half. They have now extended it to age 72.
They gave you 2 years. Well, year and a half.
They gave you a year and a half. Okay? So is it impactful? Yeah, you get another year and a half deferral. So it does have some positive income tax implications, but nothing terribly positive, from the standpoint of really having significant change in taxes. What are some of the other positives? The other positives are that if you're a small business owner and you want to establish a pension plan, the first $5,000 in terms of cost of establishing that plan actually is a credit.
So establishing a pension plan for your employees?
For your employees.
Who does that anymore?
Well, some people do. There's some administration expenses. 401ks are still very popular.
Yeah. Just you don't hear about the pension so much anymore. We were just talking about that off air.
You don't hear much about pension. You don't hear, much about, what typically we were chatting about, like defined benefit plans and, some other real positive employee benefit programs. Those plans are, for the most part, pretty much gone. Okay? And the reason for it is really quite simple. It's now been a transfer of the responsibilities. It went from the employer, who was making most of the contribution. Now it's the employee who is now obligated to make those contributions to meet their retirement planning needs on their behalf, which is why they're using their own funds.
You're talking about under the 401k umbrella?
Under the 401k umbrella,
yeah,
exactly.
That makes sense.
Yeah. So, with the defined
no one's even matching so much anymore. Is that what I'm hearing?
Well, the matching, I think, is changing. I've set up plans recently where there's been zero match. Okay? And, you have some complications in terms of meeting the testing requirements. If you have that certain employee who says, listen, I'm free to, I'm happy to offer this plan to you, but I'm not making that 3% contribution.
Right.
Or I'm not making the 50% match.
So the great thing about starting your own business is starting your own pension plan where you can do not only for your employees, but for yourself.
Absolutely. Okay, so there is some tax benefits in terms of the credit.
Yeah.
There's some positive attributes for younger people after their first child is born. Okay, so if you have a 401k or a pension plan and you have a child that's born and you want to take some money out of your 401k without additional taxes or additional penalties, you can now do that up to a $5,000 threshold. So there's some interesting little tidbits to the new act that gives some nice benefits to the employer or to young households who are having their first child or any child for that matter.
Tell me, and I don't know if this relates to the Secure Act, is it possible to take money from your IRA and also purchase homes for the first, not even the first time, but if you want to use it to purchase a home?
Most of the better plans have loan provisions. Okay, so if you do have, in fact, a 401k and you have a vested benefit of a fair amount of money, so let's say you've accumulated, let's say $50,000 in that plan.
Sure.
Most of the better design plans will allow you to borrow up to 50% or $25,000.
So they can take 50% of whatever's in there.
Correct.
Without penalty.
That's correct.
And then they put it on a home, and then if they sell the home, they have to give it back, or how does that work?
Well, they do. They have to give it back because ostensibly you're borrowing your own money.
Okay, and if you don't, when do you have to pay it back?
When the house is sold.
Okay, so then if they're going to put that in another home.
Well, they could do that.
Okay.
They could do that.
Might be a way to actually get your retirement money working for you now.
Well, you're basically using your own retirement assets. Mm-hmm. You're basically giving yourself a rate of return versus an ancillary investment. So instead of investing it in stocks or bonds, you're investing it in your house. And yes, there's an interest factor that needs to be associated with that. And mitigate some of the transactional costs by going to a third-party bank or other financial institution in terms of borrowing money to purchase that house.
So that could be a great benefit.
Oh, it's a super benefit. Yeah.
Okay.
It really is a super benefit.
So you advise clients sometimes to do
yes.
that if they don't have a down payment and they want to.
If they need some money to meet some of the additional financial requirements in terms of the purchase of their first home, using those funds is not necessarily a bad thing.
Yeah. And back to the Secure Act. I'm sorry I interrupted you when you were talking about all the positives. Were there any more positives? I think that's not a good sign.
I'm waiting.
I think so far
nothing that really comes to mind, unfortunately.
Well,
there was some concessions in terms of being able to get some tax benefits in terms of the cost associated with setting up a plan.
Yeah.
There was the threshold that changed from 70 and a half to 72. There was
just a year and a half.
Just a year and a half. There's some benefits to people who are having a child to be able to extract some money to be able to meet some of those costs and expenses regarding a new child into the household.
How often do people actually extract money for that reason?
To
buy a crib or to buy, right? That's what we're talking about. That's what you have to. You have to prove that you're using it for those reasons. Or
you don't. You can, as long as you can document that you have that there's a birth of a child, you can take out $5,000.
Oh, okay.
And now with infertility or something else,
you bring up a good point.
IVF, both my children, very expensive, and there's very little third party or adoption.
Yeah, that gets expensive too.
Okay, so but it's only $5,000.
Not a lot.
It's not a lot of money.
It's not going to cover a lot for IVF.
It's certainly not going to cover a lot for IVF.
That's probably the first visit.
Right.
Right.
IVF can be $20,000 to $25,000. Okay.
Yeah.
Adoption can be even more expensive than that.
Wow.
So those unfortunate families that there is some fertility issues. It gives you a little bit of a threshold in terms of mitigating some of those expenses in terms of using your retirement account without adverse tax implications.
Yeah.
But again, it's $5,000.
Now, the old act, didn't it basically give you kind of like a lifetime guarantee on your money of, you could keep transferring the money from generation to generation?
Well,
is that how it worked before the Secure Act?
Exactly. And that's the real negative that this act imposed. Because now, between spouses, you have the same intrinsic benefit. So between a husband and wife, if one spouse dies, the other spouse can inherit those funds and continue to take those monies out based upon their life expectancy.
And it's always been that way.
And it's always been that way, and that hasn't changed in terms of the new act. The real implication really comes into play when both parents pass away. And now we're transferring the money to children or, let's say, grandchildren. Mm-hmm. The old act was extremely beneficial from the standpoint of doing what we commonly refer to as the stretch IRA. The stretch IRA ostensibly was the ability of a parent transferring their retirement account to their children or grandchildren and have that grandchild or child take that money out over their life expectancy.
The grandchild could take that out over there. Oh, that's nice.
Okay, so by means of example, if you had a 70-year-old grandparent and wanted to make some nice contributions for the benefit of their grandchild, before the
Granny
act,
contributions.
exactly. That contribution could have easily been made to that grandchild at the time of the death of the grandparent. And then that grandchild now has, over their life expectancy, which could be another 70, 80 years, be able to have the benefit of that money and that money growing on a tax-deferred basis throughout that 70, 80-year time frame, with their minimum required distributions being predicated on their age, which is, for the most part, for a grandchild, relatively small.
Right. You had more choice with your money. You actually had more say, more freedom.
It's really a function of compound interest.
Yeah.
It's really a function of having that money protected, and free from creditors. It's really more effective from the standpoint of meeting some of the cash flow needs of, children or grandchildren. That benefit has now been eliminated.
Okay.
Okay, so now the benefit or the beneficiary going to a child or a grandchild, they now have a deferral of only 10 years.
Very short compared to lifetimes.
Exactly. So let's use an example. Let's say, and this impacts everybody. So you have an IRA that's worth $100,000, and the parent passes away, and you want to transfer it to the child.
To the grandchild, to the grandchild from their parent, or
either to the child or to the grandparent, or to the grand. So let's just say the child, the 50-year-old.
Okay.
Okay. So that 50-year-old now has $100,000 that they now have to take out, based upon the new law, assuming no growth.
22 years.
No, 10 years, $10,000.
Oh, because they start, yeah.
So
because they inherited it, so then you have the 10 years.
Exactly. So they have to take out $10,000 a year, and they're paying income tax on that $10,000 a year.
Hope they found a good investment.
Okay, so that so that $100,000 is going to be eroded based upon the income tax bracket.
Yeah.
20, 30, 40%.
Wow. Okay. So you could really deflate a
versus that money that would have been typically in a IRA beneficiary account that could have been deferred over a 40-year time frame.
You could really have some interest on that.
So if you look at the difference in terms of the ability to accumulate wealth in a tax-favored environment and the income tax implications that it involves, it's outstanding in terms of the difference that this new act has imposed.
Do you think there's enough uproar out there that people are lobbying against this, or is it so new that people don't really understand?
I think it's so new because the act just became effective as of January 1st of 2020. Yeah. Most advisors are not even aware of the implications.
Oh, well, that's a problem.
Okay, so we're really at the beginning since today's February 13th. So you're 6 weeks into this new act, and quite frankly, most professionals know very little about it, and certainly know very little about the implications that's going to present itself as it relates to their clients and the income tax issues associated with those clients.
Yeah, nobody wants to pay more taxes.
Nobody wants to pay more taxes, and many people who were thinking that at the time of their death they had no estate tax liability or no tax liability, now they have this significant income tax that they weren't anticipating.
Yeah. And it doesn't matter if you're really wealthy or middle class, everyone's affected equally.
I'm having this conversation with clients who have $100,000 in their account, and I met with an accountant today who has clients that we were discussing that has a $10 million IRA and a $20 million IRA. Yeah. The numbers, the taxes are there regardless of the amount of money that's in the account. Yeah. And what's sad about it is the lost opportunity that this new act has provided in terms of an income tax deferral that we could have previously taken advantage of, which we've now lost.
Well, when we come back, I want to talk about what we can do. So there's got to be something that we can do with our money, even though this act is in place. But give folks your phone number and how to contact you.
Sure, be delighted to. Again, my name is Paul Labiner, conveniently located in Boca Raton, Florida. My telephone number is 561-998-2362.
And we will be back after this short commercial break. And we are back with Ask the Expert, and I'm joined by our expert, estate attorney Paul Labiner. Paul, we left off talking about the Secure Act, how it impacts basically everyone, no matter rich or poor. We're all getting higher taxes basically and losing that tax benefit. What are some of the options that we can basically take advantage of to kind of mitigate the loss that we're going to be experiencing?
Well, I think there's one obvious one, and that is use it during your lifetime. Spend more money.
Spend more. Well, how about invest it somewhere?
Oh, okay.
Because that money's going to go fast.
So that's certainly one option, and I'm often when I've been doing this for over 40 years now, and when I talk about estate planning, and people don't like to talk about their death. Obviously, people don't like to think about what's going to happen after their demise. And so the logical question comes up. Well, what do you want? How do you want to distribute your assets upon your death? And they said, well, I'm going to spend it all.
Yeah.
That's I've heard that hundreds of times.
They're just going to spend all the money.
But that never happens. Okay.
So they outlive their money most of the time.
Regardless of the net worth of the client, there's nobody that leaves virtually nothing. Or I should say, most people don't leave virtually nothing.
I think that's great because the common fear is that they will outlive their money.
Well, I think that's a big concern. I hear
that a lot.
Yeah, that is a big concern, and that sort of relates to the conversation that we're having today in terms of retirement planning and making sure that those monies that they do have, are used efficiently, for their benefit first and foremost. And I think that's, I think people need to be selfish.
Yeah.
I think, what I'm talking about today as it relates to the Secure Act is really more of an unselfish motive, in terms of how to maximize those assets for your loved ones upon your passing. But there's no question that there's a selfish component that needs to be taken into account. And
so that you don't have to live so, what's the word, budgeted?
Well, so frugally, yeah.
Yeah.
And there's so many variables. It's how old you're going to be, your health.
Should add a little. It's just ringing a little bit.
It's ringing about, okay. So I mean, there's so many different variables that that need to come into the equation. And most people just don't give that enough thought and consideration
themselves.
Yeah.
Yeah.
And that's unfortunate.
Yeah, I do find that I'm hearing people saying they're working longer too.
Well,
I think that's helping them not outlive their money.
I think that's
still
true.
Making it, and that's comforting, right?
That is comforting.
Yeah. So, is there any other planning options that we have?
Well, I think there's, I've been discussing a lot of different options with my clients, besides just using the money and spending it.
Which sounds very fun.
Well, it could be fun, but most people are not going to take advantage of that.
They must look at you a little crazy when you say that, right?
Well, listen,
You're the only financial planner saying go spend your money, right?
I want to give them all the options and want to give them, something for them to consider. One option that I really like, that I've been discussing a lot with clients, is instead of naming their children or grandchildren as the beneficiary,
okay,
they name a charitable remainder trust. Now, I'm going to get a little bit sophisticated, but I think it warrants a conversation, because what are some of the intrinsic benefits of naming a charitable trust in lieu of naming your children or grandchildren? Okay, well, there are many, and you don't need to be charitably inclined to take advantage of this.
So you're saying you don't have to care about anybody. You can
you could still be selfish and self-centered, and still be able to incorporate some really interesting planning techniques.
Yeah.
So by means of example, the charitable remainder trust is a wonderful technique, because you have the benefit of that same deferral as you would under the old stretch rules. You have the same intrinsic benefit of being able to have those monies be stretched out over the lifetime of the beneficiaries, whether it's your children or grandchildren or both for that matter. And there is a component to address some of your charitable or philanthropic planning.
And how much would you have to give them?
Pursuant to tax law, there needs to be, based upon the calculations that we do when we set up these trusts, there needs to be at least 10% left at the time of the demise of the children, for example. That's ultimately going to go to the remainder men, which is their church, their synagogue, the Cancer Society, or what have you.
So they're holding $100,000 in there, and then just by the time it's going to be transferred to the grandchildren,
but by the time it gets transferred to the charity, $10,000 ultimately has to go to the charity.
Okay, so it's at the end. Okay, so that's great. That's a great tax shelter.
Well, it is a great tax shelter. Well, think of the arbitrage, because without using the child remainder trust, 30 cents on a dollar is going to be eroded to income taxes.
Right.
Okay. By using the child remainder trust, and I'm generalizing to some extent, is instead of losing 30% to income taxes, you're really only losing 10% to the charity. Yes, the kids are going to be paying some taxes along the way, but you have that deferral opportunity over.
So they're paying taxes on the $90,000
that comes out, but that money is growing on a tax deferred basis
for
a much longer timeline. So when you crunch the numbers, and I've crunched the numbers, and you look at the analysis of the 10-year stretch under the new rules versus incorporating a child remainder trust, the numbers are outstanding in favor of using the child remainder trust in lieu of just simply an outright distribution to the kids.
Yeah.
And you're accomplishing so much. You're still providing the cash flow, for the benefit of the children or grandchildren.
Yeah.
And there is that charitable component or philanthropic component that, most people can wrap their heads around.
It's like you created your own IRA.
Well, you have.
Yeah. That's great.
So that's a wonderful...
Until they invent a law on that.
Well, unfortunately, typically, when when you incorporate these plans, based upon current tax law, they don't necessarily reverse those set of circumstances. So for those people who died prior to January 1st of 2020, their beneficiaries have the ability to continue to use the stretch component. So they don't have to they don't have to use the new rules.
Wow, that's great.
That's
is pretty. So you just thought of this on your own?
Well, thankfully we have a universe of professionals nationwide, and we meet and we have conversations and we have classes and continuing education programs. Another technique may be, depending upon the facts and circumstances of the client, is to take out more money.
Take out more money, okay.
Okay.
And do what?
Fund an irrevocable insurance trust. Use some of those monies to buy life insurance on mom and dad.
Okay.
So even if you depleted all of that money.
So let's say I have an elderly parent.
Okay, well,
I have an IRA. I'm taking that money out and putting it in life insurance for them?
That's correct.
Okay. And then how does that...
Well, how does that work? Okay, so let's take...
We have just a minute here.
You have a minute. Okay.
So should we save that for the next discussion?
No, we could save that for the next discussion. But suffice it to say, call my office.
Yeah.
At 561-998-2362. There are wonderful options and planning opportunities, whether it's the child remainder trust, whether it's the use of the life insurance, whether it's to convert the IRA to a Roth IRA, or some combination thereof. There are nice, attractive, very pertinent planning opportunities that can be incorporated that warrant virtually anybody's consideration.
I didn't know you could convert an IRA to a Roth. I thought... Wait, I guess that's the one I didn't realize you can convert to.
So the Roth conversion is another planning opportunity that we're beginning to incorporate more and more.
Yeah, let's talk about that next time as well. I think that's interesting for folks, and then how that benefits.
Sure, be glad to.
Well, give folks your phone number one last time.
Be delighted to. Again, my name is Paul Labiner. Please give me a call. I'll be delighted to meet with you with no fees, no
free.
No commitment at 561-998-2362.
Thank you, Paul, for coming in tonight as our resident expert.
Thank you.
And we did learn a lot, and I look forward to learning some other things about how to basically make my money work for me.
Thanks, Rhonda.
And we'll be back after the short commercial break with Envirotech.